being scientifically challenged has the burden of proof. What happened in Lowry? In Lowry, the defendant made a motion to preclude the plaintiff's evidence, and the plaintiff ended up with a burden of proof to try to prove something with few facts on the ground. In Nobre, we made a motion. Nobre, again, is the one with, I'll call it barely a permanent injury based on the defendant's physical. And I want you to think about this. In Nobre, we make a motion. We put into the motion everything under the sun. Just, literally probably 6 feet of literature, affidavits from multiple experts in multiple fields, even though they have the burden of proof, and emphasize to the court every single time this is discussed, from the first time to the last time, who has the burden of proof. And they put in their papers, and I thought their papers were weak, and there was going to be a hearing. And I took a chance, and I want you to think about this. I said, you know what, Judge, this emphasizes who has the burden of proof. I cross-examined their pediatric neurologist, I cross-examined Dr. Brick, and I didn't put on any witnesses. And I said, Judge, they have the burden of proof, and this doesn't meet it. And the court agreed. Who has the burden of proof? There was a case in New York following Muhammad, and the plaintiff moved for a preclusion and misguidedly, unfortunately, thought they had the burden of proof, and put experts that some of us know on for days and days of cross-examination, went nowhere, and ended up withdrawing the application. Remember who has the burden of proof. It's very difficult, if this is approached in the right way, for them to prove the maternal forces theory. Now, again, I'm out of time, I think, but I've really barely touched the surface of this. If anyone has any questions, I'm happy to answer them now or at any other time. Anybody?
Our next speaker is